Well, good afternoon, everybody. I believe we are live on YouTube and Facebook. And so this is something that we do every couple of weeks. It's the Legal Ease Show where we try to make some of this seemingly complicated stuff a little bit easier to understand, talking about credit reports and debt collectors and collection lawsuits. And normally I have my partner in crime, Steve Palmieri here, but he was busy today. So you will have to make do with me today. So the point of this is not really for me to give a presentation. And I don't really like listening to myself talk too much anyway. So the point of this is for you guys to post questions. And you can put those on the comments and we'll just go through. And as long as there are comments and questions, then we will try to answer those. And I've got probably an hour or so. And so let's see here. We've got Alrico Perkins. Greetings from California. Well, hello there in California. And oh my goodness. I thought that I would do this whole show without Stephen, but as Stephen likes to remind me, he is that guy, even though he always says, I hate to be that guy. Truthfully, he loves being that guy. But hey, good to see you, Stephen. Hope everything is going well. And Rika, thank you for the valuable info. Well, you're very welcome. And my pleasure to share anything that I can that will be helpful. And so let me give kind of a little bit of an update because it's been, I think, maybe it was a month ago that we did this. And just give you a little bit of an update from my vantage point of what I am seeing. And then I'm curious what you guys are seeing. In terms of the FCRA, Fair Credit Reporting Act, dealing with credit bureaus, we are still seeing a lot of the disputes that we know have been delivered to credit bureaus just being ignored, just like completely unresponsive. And I'm not talking about we send a letter by first class, envelope. I mean, we do certified mail and they sign, we know that they got it and they're just doing nothing with it. And so I thought that would probably diminish the further we get away from COVID. It was not much of an excuse. But, the excuse was, well, COVID and people working from home, we just can't process this stuff. Well, the law is still the law. You still have to process it. But, we still see some collectors and credit bureaus go, well, there's this thing called COVID and like nobody can work. Like pretty much sure we've moved past COVID. So I'm surprised that we're still seeing that high a percentage. And so that's what I'm seeing on the FCRA side, just, stuff not getting corrected and just very blatant errors. And from the FDCPA standpoint, Fair Debt Collection Practices Act, so dealing with debt collectors, what we're seeing is, let me take a step back. There was Regulation F, which came into effect November 30th of 2021. And that made a lot of changes to the FDCPA, particularly in how a collector communicates with you. Can they send you a text message? Yes, they can if they follow the rules. Can they email you? Yes. Can they send you a Facebook message, Twitter message? Yeah, if they follow the rules. What about limits on number of calls and things of that nature? And what I am seeing is that there's not been a huge change in the communication. So I am not having many clients that are getting text messages from debt collectors or even email. So I'm very curious what you guys are seeing out there. Are you seeing, either if you're a consumer for yourself or if you run a credit repair organization, are you seeing your clients, your customers get text messages, get emails from debt collectors? I'm not talking about scam companies, where you get the message like, Western Union me $100 or you get a jail. I'm not talking about that. I'm talking about real companies doing this. I'm just not seeing a whole lot of that. Now, we're certainly enjoying the ability to send letters to collectors and tell them, here are the only ways to communicate and the only times to communicate. That's a very powerful portion of this law. Some other areas of the Regulation F maybe are not the most consumer friendly, but we can now dictate to the debt collector, here's the only convenient way for you to communicate with me. Maybe it's by text, maybe it's call, maybe it's letter, maybe it's, email. And here are the times to communicate. Now, you really can't do that with the letter, but you can say, only email me during this window, or only text me, or only call me on the weekends. But during the week, only want a text message between 6 and 9 p.m. or whatever it is. And that is proving to be very helpful. So I'm curious what you guys are seeing out there, and then certainly any questions you have. So let me see. Jason asked this question, able to ask debt questions, or is it credit reporting? Absolutely, Jason. Anything related to collectors, the FDCPA Fair Debt Collection Practices Act, credit reports. And if I can answer it, I will. And, occasionally people ask about foreclosures and other stuff, and I'll certainly answer anything that I can. But generally, we keep it focused on dealing with debt collectors, debt collection, and credit reporting. Let's see, Jason says, how come I'm assuming that's debt collectors, think they can collect without a contract? So we have to distinguish a couple things here. One is, if we're talking about a debt buyer, so somebody who claims to have bought a debt. So we're talking about like Midland Funding, Midland Credit, Portfolio, LVNV Funding, those types of guys that say, hey, we bought this debt from Capital One or Synchrony Bank or wherever. Then they don't need a contract between them and you, because they say that they have bought the contract that existed between you and Synchrony Bank, and that now they stand in the shoes, or they've stepped into the shoes of Synchrony Bank, for example. Now, there's a big difference between saying that and proving that. If they sue you, my view is, and has been for many years, they have to prove that they really own that debt. Now, if it's a third-party collector, what we generally call sort of a traditional third-party collector, so a doctor's office still owns the debt, but they send it out to XYZ company to collect it. Again, they don't have to have a contract with you. They just have to have a contract, obviously, between them and the doctor, and then there better be a contract between you and the doctor. Now, sometimes that is what the law calls an implied contract. In other words, you go to the emergency room, you're not signing something. But normally when you go to the doctor's office, you fill out like a financial responsibility form and say, I agree that I can be collected against. And so hopefully that answers some questions there. And let's see. Jason says lots of texts and emails. So I would like to know a little bit more about that. If you know the name of the company, have you looked them up? Do they look like a legitimate company? So I'll tell you this: the company that I know of the most sending emails, for some reason I'm drawing a blank on it. It's True Accord, I think. I've always seen them collect for LVNV. I don't know if they exclusively collect for them, but I'm curious what some of the names of the companies are that you guys are seeing either send emails or especially text messages. I've only seen one. It was somebody I wasn't familiar with sending text messages. So I'd be curious about that. Let's see. Bryce says emails and orange envelope collection letters. So I'm assuming, Bryce, you're saying you're getting emails and then actual physical mail coming in. So again, I'd be curious who's sending those emails. And let's see, CJ says, I have a question. Does check systems have to abide by the FCRA rules? And the answer is yes. So to the extent that check systems is a credit bureau, and that's defined under the FCRA, Fair Credit Reporting Act. And so check systems, usually is involved in like making sure that what your history is with, writing checks and things of that nature. I'm trying to remember if they get into sort of bank accounts and whether you've ever had an overdrawn account and things like that. But yeah, those companies are credit bureaus just like Equifax. And the CFPB, Consumer Financial Protection Bureau, puts out a list every year. They put it out in January. You can just Google it and find it. And this list a bunch of specialty reporting companies. Now, there's a lot more than what the CFPB puts out, but I mean, CFPB probably puts out 50 of these things. There'll be a couple of check cashing. There'll be some background screening. There'll be some landlord tenant. What's been your experience with dealing with renting properties? Have you ever broken a lease? Have you been evicted? And I've said this a number of times. There was a credit bureau for truck drivers. Had nothing to do with their credit reports as we think of it. It was, have you backed into a sign? Have you had an avoidable accident, an at-fault accident? And so there's all sorts of credit bureaus. So certainly check systems would have to abide by the FCRA. So if you find information that's inaccurate or incomplete, then you could certainly challenge that. And let me just show you this. So this is section 1681I. And this, I know I show this a lot, but I want you to see the actual law. It's not just me saying this, but here's what the actual law says. And so this is dealing with credit bureaus like check systems, for example. And so it talks about, let me get this highlighted if I can. So we've got, if the completeness or accuracy of any item of information contained in a consumer, that would be you, consumer's file, your file is all the information the credit bureau has on you, at a consumer reporting agency, and check systems would be that, is disputed by the consumer and the consumer notifies the agency directly or indirectly through a reseller, such dispute, the agency shall investigate. And now I'll say this sort of full disclosure. If I've had a case against check system, it's been a long time ago, but my memory is that they are a credit bureau involved in, with checks. So anyway, anything to do with the FCRA, if it's whether it's sort of a big credit bureau, a small credit bureau, a credit bureau that just reports on your medical history, believe it or not, there's one of those. On your rental history, all those people are subject to the FCRA. It's a very good question. And let's see here. Golden Queen Diva says, I have a collection account where the balance has increased $5 to $6 monthly over the past 3 years. How is it possible since I never had an agreement about that? It's over double the original amount. So what I would say to you is you have to look at the underlying transaction, okay? Does that underlying transaction say that there will be interest accruing, okay? Is that what this is? It sort of sounds like it, that there's interest. And then, so it's kind of two steps. One, does the contract or the agreement allow for interest? And then does the law allow for interest? So in other words, typically, and there are exceptions, but typically charged off credit card debt, we normally don't see interest being added to that. There are a variety of reasons. It can involve whether or not they're sending you monthly statements. Maybe if they're not sending monthly statements, they can't charge interest, okay? So you have to look at the law, and that can get a little complicated. Maybe Truth in Lending Act, it may be a state law. And so what does the contract say? And what does the, obviously I forgot to turn off the ringer on my phone there, and then I apparently knocked it on the floor. But we look at what does the contract say and what does the law say about whether that's allowable. So there's no blanket rule. In other words, sometimes it's perfectly legal and allowable for them to do this. Other times it's not. And let's see here. Yeah, it's called plain old debt collector. Yeah. So, what sort of growing up, I would say, at least for my age, when we thought of a collection agency, a debt collector, we're talking about, plain old debt collector, a third party debt collector. And that's somebody who makes no claim to owning the debt. They just say, hey, we are collecting on behalf of somebody. And that's compared to and contrasted with a debt buyer who claims to actually own the debt. Okay, so two different things, but they're both considered debt collectors under the FDCPA. Let's see, Jared. Hey, Jared. Good to see you on here. What's up? New law coming in effect mid-year of medical debt under 500 being dropped from reports. So two aspects of that law. And let me take a step back. The CFPB issued a report, I want to say February, where they basically said, we're concerned about medical debt, and particularly on credit reports. And so last week, the credit bureaus, Equifax, Experian, TransUnion, now none of the others, but I suspect they'll follow suit. But the big three said, hey, as of July 1st of this year, 2022, any paid medical debt will be deleted. And then I think it's in the first half of next year, any medical debt under $500, so that would be unpaid medical debt, will be deleted. And I think no medical debt can be reported less than a year after the debt was incurred. And I'm not sure exactly how detailed that gets. Is it when you underwent the procedure or when they first billed you? Because sometimes you go see a doctor, go to the emergency room, it may be 6 months before you get the bill. And this is designed to give some time so that you can work things out instead of just boom, being hit with some collection and that damaging your credit. And so overall, this is a good thing. Okay. I absolutely think it's a good thing. There may be some unintended consequences. So, sometimes we'll see collectors, traditionally, this is what they've done. Let's say I have five $150 bills with a particular medical provider. Well, they would do five separate trade lines, five separate accounts on my credit report. So I'm getting hit with five different collection accounts. Well, at least as of next year, that's going to be hard for them to do. But maybe they'll now bundle it together to get over that $500 mark. And by the way, that 500 is, it's going to be at least 500. The credit bureaus might set the standard a little bit higher. But what we may see is a little bit more aggressive medical collection where they are putting the stuff over $500 on our credit report and then saying, you got to pay it if you want this off. And, that can really jam you up if maybe you're close to buying a house and then boom, all of a sudden, just this medical debt out of nowhere comes on there. It may tank your score 100 points and your loan officer's like, sorry. So they have a lot of pressure and leverage by putting that on there. Now they can do that right now. So again, this is better than not having this. And it's not a law. This is just the bureaus acting. I don't think out of any, great love for consumers. They know the CFPB was getting ready to drop the hammer on them. So they're trying to get out in front of it is my view. So overall, I think it's good. July, paid debt will come off. And then next year, we'll see that at least $500 and below will not be reported. Let's see here. Okay, so here's an interesting one. Alrico says 100% disabled veteran. My student loans were discharged. I received a 1099-C. They're still showing on my credit report. So, Alrico, if you're still watching this, my question would be, I'm assuming we're talking about federal student loans because there is a provision where if you're disabled, you can get those federal student loans discharged. Private student loans are kind of like, a signature loan. It's just really hard to get rid of in bankruptcy. So I'm assuming you mean your federal student loans. And I'm curious about the 1099-C. And I'll be honest, I am, not a student loan expert. There may be some that are on this call. I don't know if Charles is on this call, but so I'm not real familiar with how that student loan discharge work, which is totally different than a bankruptcy discharge. Okay. I don't know if that's a taxable event, if you're supposed to pay taxes on that. My hunch would be no. But if it's just a 1099-C in the sense of, hey, this is, debt that we are not, planning on ever collecting, the courts are kind of split on should that remain on your credit report, should it not. If it was me, I would dispute it. And I would say, here's a copy of my 1099-C. Maybe you get a copy of your discharge letter from the Department of Education, who I assume you would get it from. And you send that to the credit bureau and say, look, my loans got discharged. Here's a 1099-C, and I believe this means that I do not owe this debt anymore. Get this off my credit report. Certainly show it as a zero balance. And there should not be any negative reporting after the discharge. But I would see what you get with that. There are some courts that say it's okay for them to keep reporting. Others say it would be incorrect to report. So if you'll follow up with us and let us know what happens with that, you may have good luck with it. And I think it'd be worth doing a dispute over. Let's see. Jason said, I think these are some of the ones that are contacting MRS Associates. I know that one. And Zotec Partners, not familiar with them, but that's interesting. Just my clients, at least that they tell me, have not been getting many emails or text messages. So very interesting. See, AJ says, if a default judgment is satisfied, paid in full, can the collection company who reports this on my credit report have any standing in court? I initiated a lawsuit against them in small claims court. So I'm assuming we got sued and they got a default judgment against us, and then we satisfied or paid that. And so normally that judgment would not be on our credit report, but the company that owns that debt might be. So maybe this is like a Midland Funding or a portfolio recovery. And so now you sued them in small claims court. So when you say standing, I'm going to sort of take this in the technical legal sense. Standing means the ability to go into court. It doesn't have anything to do with the defendant. It's really the person who files the lawsuit. So we only look at standing on behalf of the plaintiff, the one who files the lawsuit. So they would have the ability to defend themselves. Now, maybe what you're meaning is the fact that the debt's been paid, that might impact their ability to defend the case. It would just, I think, depend on what you have sued them for. And is that connected to the judgment? Maybe they're reporting that you owe the debt even though it's been paid off. Well, that would be very helpful if, for example, Midland Funding had a judgment against you for $5,000. You satisfied that. They show it in the court as being satisfied, but yet on your credit report, they say you owe $5,000. So we do cases like that. And, we dispute those through the credit bureaus, and then we sue the debt collector and the credit bureaus when they don't fix it. And so it just depends on exactly what you've got there. Let's see. JD Lewis says, can I request a detailed statement from when the account first opened from a debt collector, even the original creditor? Do they have to send it? So the first question is yes. You can certainly go to either a creditor or a collector and say, give me, all the transactions from the beginning to right now. Okay. Now, generally, they don't have to give that to you. Okay. So what I always recommend is explain to them why you want that. Okay. Maybe you have questions about some of the charges. Maybe you have questions about the interest or the late fees or proper crediting payments that you made. I would just say, I need this information because, and then put that in there. So again, they generally don't have to send that to you. The one exception would be under the FDCPA, Fair Debt Collection Practices Act, for a collector, if in this period of time called the validation period, and that's under section 1692G. And by law, it's 30 days, but this regulation F kind of, in essence, encourages collectors to extend that and to give you sort of a date certain. So you might get a letter dated March 1st that says you have till April 15th to request this. If during that time period you request it and you can show why you need it, then they may need to respond to you by giving it. But otherwise, they may not have a legal obligation, but there's a sort of a psychological obligation and sort of a legal obligation. if you're saying there are problems and you're asking them to give you proof and they don't, well, that makes them look bad if they're wrong. And if they come back with something called a bona fide error defense, said, yeah, we violated the FDCPA, but it was a mistake. We had all these procedures in place. Kind of hard to do that if you ask them for information that would have shown them they were wrong and they refused to give it to you. Now, the only other thing I'll say is under some state laws, creditors can be treated in a similar way as debt collectors, because you may have a state law that kind of takes the FDCPA and says this applies to creditors also. So I think in California, the Rosenthal Act, Florida's the Florida Consumer Collection Protection Act, it's FCCPA, I think. So different states have that. Now, a lot of states don't. So Alabama, for example, has nothing like that. So you may be able to do that to creditors as well, but I think it would be that same thing. Technically, it's got to be within that validation period, and you need a reason for it. But if you're way outside that validation period, I'd still ask for it. And, generally they will send that to you because they're nervous about it. All right. So see, Ray says, how can I collect my money from charge-offs? So I'm assuming you mean you had a charge-off, like a Capital One account was charged off, and you're saying, how can you get your money from that? Well, unless Capital One breaks the law and you can sue them, I don't know of any way to get money that you paid them back unless they somehow owe that to you. Let's see. Muriel, hello, everyone. Good to see you, Muriel. And let's see. Carlos, hello, John, and everyone. I have 2 Midland accounts and sick them, want the suit to make it public. So, Carlos, have you beat those Midland accounts, or are you still facing those? So that's what I'd be curious about. Let's see. Jason says, so my question would be more specific, would be, how can a debt collector collect on behalf of its original creditor client and you ask for a copy of the contract, they don't produce it within 30 days? So again, it goes back to that validation period. So your ability to demand that they produce certain things, and I'll come back to that, is only within that validation period. Now you can request it and they probably will give you some of this, but your ability to make them validate or verify the debt is technically only in that 30-day window. Now, even within that window, it would be very unusual to be able to force them to give you the contract between them and the creditor, because that's, between those two. Now, if you mean the contract for the debt, yeah, they should give that to you. Frankly, they should give that to you whenever you ask for it. The other thing to keep in mind is, even if you're within that validation period and you request something, and let me back up. Some courts say if you just do kind of a generic validation request, the collector can literally go, hey, creditors, he owe this? Yeah. Okay. Yeah, we validated the debt. And if they own the debt, they go, hey, self, does Jason own this debt? Yeah, he owns it. He owes it. So it doesn't even necessarily mean that they have to produce documents. But even if they don't respond, there is no time period for them to respond. So it's not like if you request in that validation period, they only have 30 days. There is no time limit for them. They just can't collect until they respond. They could take 3 years to respond. That doesn't violate the law. They just can't continue to collect without validating the debt. But again, I just caution you, the law is not very good on what they have to produce to you in validation. But the more specific, targeted, and the more you explain why you need certain documents, that's going to create a greater obligation on them. So if we just say, hey, I dispute this debt, validate it, they don't have to do anything. I mean, they just go, does he owe it? Yeah, he owes it. Okay. But if you say, hey, 6 months ago, I paid off that creditor, here's a copy of my check. You can see that it was cash. Here's a bank statement showing the money went out. Go back and check with that creditor, and you'll find out I do not owe any money on this. Well, now if they just go, hey, CC, yeah, okay. Yeah, I mean, now they got to like dig in. Hey, what about this check? 1, 2, 3, 4 for $650. What about that? What'd you guys do with it? So the more detailed we can be in our request for validation, the greater the obligation is. But there's some things the court may just say, no, they don't have to give that to you. All right. So when asking for validation, collection agencies, should we be asking specific information such as contracts, proof that they can even collect? Yeah, you can ask for that. I would just always explain why. So the pattern is I need X, Y, and Z because, and then explain. So I need to understand why you have the right to collect in my state because I looked you up on the banking department website and I don't see that you're licensed as a debt collector authorized to collect in my state. Now, obviously, whatever you say, make it true. So, with that, now there's going to be a little bit more obligation. If you just say, show me proof that you can collect, well, they might just say, we can. If it's all publicly available, you could look it up. So I would try to do everything I can and then ask them for what you need and explain why you need it. So, let's say it's a debt buyer and they send you 2 statements. And the first statement is you start the balance at $4,567. And then the next statement is like the next month. Well, what about before that? I mean, how did we get to $4,567? So, hey, debt buyer, I need you to go back to the last time it was at a 0 balance. And, what's the interest rate? Because I don't know how you figured the interest on this. Or, and show me a copy of the contract because I want to see what does it say about late charges and over the limit fees and the appropriate interest rate. So you just want to explain why you need what you're asking for. Rico, yes, it's federal. So that's on the student loan. Okay, very good. And like I said, maybe some other people may have more insight into, do you pay taxes on discharged, again, not bankruptcy, but just discharged student loans. Oh, and actually I see here, yes, I did pay taxes on it. Okay. And let you know what happened. Great. So yeah, I'm very curious to hear about that. Let's see. Gerard says portfolio sent me a letter yesterday dismissing with prejudice. Court is tomorrow. There's a wrong account number from credit bureaus than the statements they sent. Starting to think every document submitted was false. Going to show up in court tomorrow. Hope I get to tell the judge a lot more. Thank you. You're a great teacher. Okay. Well, hey, that is fabulous. I mean, getting it dismissed with prejudice in my book and actually in my state, Alabama, is really the same thing as winning the case. And so a couple of thoughts for you. One, if you're in Alabama, definitely reach out to me. If you're in another state, you may need to check the laws of your state or get with a lawyer. I may happen to know the laws because I work with lawyers in other states. So feel free to get with me. Just go to alabamaconsumer.com and there'll be a contact form. The dismissal with prejudice should be what's called an adjudication on the merits, which all that fancy terminology means is you won. Okay. You won the case. It's over. It's final. It's done. Okay. A dismissal without prejudice, it's like they never sued you. They get, boom, sue you again tomorrow. But with prejudice, that means it's over. It's final. Okay. So I would look at my credit reports to see, is portfolio on there? And it sounds like they are. Well, once you get that dismissal with prejudice, what you may want to do, there's a couple of strategies involved. You may want to just let some time go by, a month, 2 months, 3 months, 4 months, 5 months. Is portfolio still on your report for that account? Like you have to match up the lawsuit account with the account that they sued you on. Is it still on there? Is it being updated? Or did they just sort of park it on there from last month? But if they updated in April, May, June, July, and saying that you owe $5,000 and you got a dismissal of prejudice, that may be a good claim. And then you can dispute that through the credit bureaus. Hey, here's a copy of the lawsuit where they sued me. Here's a copy of the request to dismiss it with prejudice. Here's the dismissal with prejudice order. Get this thing off my credit report and see what happens. And so, and we do those cases quite often. And we've been doing those since probably '07, I think. And now you mentioned something about discrepancy in the number. You do have to make sure when you're looking at account numbers, you're distinguishing between the original creditor account number and then portfolio recovery's account number, because they don't use the same account number. Portfolio recovery has its own account number. And so sometimes that can explain it. But usually in the paperwork, they'll have an affidavit or something that will say this is a Synchrony bank account, whatever, Walmart or Best Buy or something, and you opened it on this date. And so you just kind of make a note of all that, and then you look at your credit report and match it up, because there could be a portfolio recovery account on your credit report that's not the same one that they sued you on, or you might have more than one, so you have to figure out which one it is. Sometimes the dollar amounts can be close. But if you say, okay, well, this was a Synchrony bank, and you look at your credit report, it says Synchrony bank portfolio recovery. And then this was open October 1st, 2014, October 1st, 2014. You can kind of bounce back and forth. Now, a lot of times it won't give you the actual open date for the original creditor, but you can see maybe Synchrony is still on your report. Generally, they're not, but maybe you have some old reports that you can find that Synchrony account. And okay, here's the date. And then, like that one will fall off and portfolio will come on. It's sort of like they swap, And so this is a great thing for you. And, certainly nothing wrong with going to the court. I would just say this: if the case is dismissed with prejudice, what else can you do? And I'll give you an example. So I was what's called clerking while I was in law school. So clerking is sort of like being an intern at a law firm. And there's this huge case that I did a lot of work in, and it got taken or removed from state court to federal court like 3 weeks before trial. It's a huge case. I mean, just so many people involved. And so we do this sort of emergency thing to get it sent back to state court. And there's the lawyer and another lawyer and me. And then on the other side, they had like 10 or 12 lawyers. A lot of those lawyers had been a clerk for the federal judge that we were in front of. It's sort of like this reunion for him. And so we're arguing back and forth. And the judge says, well, I'm going to have to send this back to state court. Well, the guy I worked for stands up, closes his briefcase, says, thank you, Your Honor, so much. May we be excused? Well, sure. You have a great day. So we get out, and it's like the other side, they're in there still arguing. And, it's like, don't we need to go back in there? It's like, no, the judge ruled in our favor. He can't change his mind now. Get out of the courthouse. Okay. So, I've taken that approach. I'll be in deposition. I might have, a whole bunch of questions, but if I get that killer question answered, I may just say, we're done, because all you can do is then snatch defeat from the jaws of victory. So I would just caution you about that. You may want to go and make sure it really is dismissed with prejudice, but I would just be careful about what are you going to say to the judge, and can you really make things better, or is there a chance that the judge could somehow change his mind? So last little story I'll tell you, I saw somebody that they were representing themselves. They were sued by like Portfolio, and the lawyer went, and then the client started talking, and the judge said, okay, I think I've heard enough. I don't think that Portfolio has proven their case. And the consumer said, well, I got a bunch more I want to say. And the judge said, well, you can keep talking, but right now you're going to win if you close your mouth. If you keep talking, maybe you talk yourself into a loss. And the person kind of smiled, like, I have nothing further, Your Honor. So just be careful about that. All righty. So, and Gerard, if you want to get with me on that, just, alabamaconsumer.com. And let me know what your credit reports say. And if you did get that dismissal with prejudice, and I would be very interested in what happens with your credit reports there. All righty. So we've got JD Lewis. I'm also a veteran who has had my student loans discharged. It should not be reporting on your credit. Yeah. And it may be that there's a policy. Again, I'm just not, specifically up on student loans. And definitely an argument to be made on any loans that are discharged. Again, we're not talking about bankruptcy discharge, just sort of discharged through Department of Education, that those should not be on there, and certainly not with a balance. And let's see, Muriel says, is it true that we asked debt collector to delete it collection 6 months earlier if near statute of limitation? I would say give me a little bit more information about that. I'm not sure I quite follow that. You're near the statute of limitations. I'll say this: if I have a client that maybe the debt buyer has another 6 months to sue, we're not going to be having any contact with that debt collector, most likely, because we want to just sort of fly below the radar and not have a suit be brought right before the statute of limitations. Obviously, every situation is different, but that's a general rule. But just give me a little bit more insight on that, and I'll be glad to answer that the best I can. Let's see, JD Lewis says, also, you need not pay interest on those loans. All those accounts should be showing paid satisfactorily and not in default. So, yeah, that's interesting. I was not aware that if they were discharged under a disability provision, that they would be showing as paid satisfactory. But I'll say this about Department of Education and federal student loans: pretty specific rules on that. So you should be able to find information on that. Let's see, Kingston 16. I'm an authorized user on a charged off account that's reporting on my credit report. Can I get it removed? The credit reporting agency is still reporting after I sent a letter. Okay, so here's, without boring you on the theoretical, let me give you just a touch of the theory and then the practical. The theory is we want authorized users to have the credit reporting on their credit report. So if my brother has an American Express card and he makes me an authorized user, that's supposed to report on my credit report. Okay. Kind of the theory is, particularly back, if we think not in real recent times, but traditionally, let's take a sort of a normal marriage, we would have the husband working, the wife not working. Okay. So all the credit would be in the husband's name. So only he would have a good credit report. Well, then what if he dies? What if he leaves her? Now she has no credit report. So if she was an authorized user, well, at least she'll have that on her credit report. Okay. So that at least is some of the theory behind some of this, from back in like the late 60s, early 70s. And so if you're an authorized user, sometimes they'll delete it if you dispute it, but they don't have to delete it. So here's the practical way. You go to whoever owns that account. In my situation, I go to my brother and say, hey, call American Express, take me off. Now, sometimes they might fuss about that if it's a charge off, but usually if the owner of the account does that, they'll take it off. And then once it's off, either it'll fall off your report or you can dispute it and say, well, here's a letter or an email from American Express or Chase Bank saying, we have removed John Watts as an authorized user on your account. You send that to the credit bureaus and say, check with American Express or Chase or whoever. You'll see I'm not an authorized user anymore. I have no legal liability for this. Take this off of my report. And I have found that they put to you this way. I've never had a situation where they refuse to take it off. They have always taken it off if you are removed as an authorized user and you tell the bureaus and show the bureaus that. So hopefully that will help you. Let's see. Somebody asked, will there be a replay? Yeah, this will be on the two Facebook pages that it's showing up on, and then on YouTube. If you go to my YouTube channel, this will be, I'm not sure how it shows up, kind of the public facing, if it's all just sort of content mixed together. When I look at it, there's sort of like videos I upload, then there are live streams. So I think when you look at it, it's probably all combined, and you'll see that there. See, Sharon says, what can I do when a company reports several different amounts, some of which are incorrect on my credit report? Well, the simple answer is if they're reporting something that's inaccurate, that's incorrect, you dispute that, and they have to fix that incorrect information, or they have to delete the account. So if there's a couple ways to kind of crack this nut. One is, let's say Equifax says, 500 experience, 600 TransUnion, 700. Well, you can sort of say, look, I mean, it can't be all three, right? Assuming they were reported on the same date. The little bit more involved way to do it is to show proof from outside the credit report that these amounts are incorrect. So give you an example. They say you paid $50 2 weeks ago. When you have your bank statement, it shows you paid $500 2 weeks ago. So you get that proof from outside your credit report. You show that to the credit bureaus and say, fix this, okay? Or delete the account. When you're showing contradictions, that showing contradictions doesn't necessarily show which one is incorrect. It's just, by definition, at least two of these must be incorrect. If for example, Equifax, Experian, TransUnion all have different dates of last payment. Well, there's only one date of last payment. We can't have three last payment. Okay. So we can show that there's some problem here. Now, we may not know until we get into a lawsuit which is correct, unless you can tell from your own records. But I would definitely dispute on that. And let's see, AJ, thank you for answering. Lawsuits with United Credit and Collections. My ultimate goal is to have this paid judgment removed off my credit report as a collection. I sue $450. So a couple thoughts for you. I'm assuming United Credit and Collections is a debt collector under the FDCPA, and that your debt was covered by the FDCPA. The judgment itself should not be on there, but United Credit and Collections may be reporting what's called the trade line or the account. I would just say, if they violated the law, I would get with a consumer attorney in your state and have them change that lawsuit, because if they violated the law, that should be worth significantly more than $450. So I would just get with the lawyer in your state, and you can go to, I'll post this link. Hopefully this will come through. It's consumeradvocates.org, and there's a find an attorney feature on there that you can look at. Let's see. JD Lewis says, can they still pursue you if this information is not provided? So I think we're going back to when we request information from a debt collector. Again, it depends on, is that information necessary for them to, quote, validate the debt? Okay. If it is necessary, they cannot continue to collect until they provide that. But if it's not necessary, then they can continue to collect. So that sort of becomes in the eye of the beholder. What does the judge say? Is this information necessary or unnecessary? I would say this: most judges are pretty tough on consumers as far as what information is actually necessary for them to, quote, validate the debt. Okay. How can anyone know what terms of repayment are in the absence of a contract? Yeah, and see, that sort of stuff is helpful. If you say to the collector, look, I don't have the contract. I don't know that you have calculated the money correct. I don't know if the original creditor calculated the money correct. I think it's incorrect. Give me a copy of the contract so I can see what the terms are. I'll just tell you this, Jason. I have not seen collectors refuse to give a copy of the contract. Now, let me clarify this. Sometimes people either naively or they get overly clever and they say, I want the original contract with the blue ink signature, and you must deliver the original contract to my house, and without possession of the original contract, you can't collect. And it's like, it doesn't work that way. Okay. We can't say, like, you give me the wet ink signature. Okay. In a lot of contracts, there is no signature. It may be done electronically. It may be done over the phone. And we start using the credit card, and under your state law, that may be a binding contract. Okay. So when we say contract, there may or may not be a physical contract there. They certainly don't have to give you the original unless there's something really, really unusual going on. But I've never seen them refuse to give a copy of the contract. So that's interesting. Let's see. Herman asked an interesting question. Can you ask Midland Credit for the amount they paid for the supposed debt that they have purchased? The answer is you can, but they're not going to tell you, and they have no obligation to tell you. And frankly, it's from a legal standpoint, it's just not relevant. Like if we're in court, it's irrelevant what they paid for it. What is very relevant is, do they actually own the debt? Okay, but whether they paid a penny for it, whether they paid $1,000 for it, either they own it or they don't. And either you owe the debt or you do not. So for them to win, and this is my view from doing this for many, many years in Alabama, is they have to show that you owe the debt. I'm talking about if they've sued you, and that they own the debt. But again, whether they paid 1 penny for it or they paid $5,000 for it, if they own it, they own it. And so I've never seen a judge make them reveal the amount that was paid. Typically, it's between 5 and 10 cents on the dollar. Let's see. Jason says, in other words, if a collector only produces monthly bill statements with no contract, how can they collect fees, interest, or costs? Sounds like grounds to go after the original creditor too. You'd have to have a basis, a law to go after the original creditor, which you may or may not have. But again, what you're talking about, you just explain that to the collector. Like, I don't think the correct interest has been charged. I don't think the correct late fees have been charged, over the limit fees. I need to see the contract to know. And you may also be interested in the contract because it may have an arbitration agreement. You may want to compel arbitration. And so I think they'll give that to you. I'd be surprised if they don't. And if they don't, I'd write them back and say, why? Why won't you give me the contract? You're collecting interest, late fees, whatever. How do you know that that's correct? Do you, Mr. Collector, have a copy of the contract? And if they refuse to tell you, I would get with a consumer lawyer because you may have some grounds there. Okay, so Shuki Greer says, is reporting a debt to a credit reporting agency an attempt to collect a debt? It's a very good question. Let me answer it this way. On the one hand, absolutely. So we have a section under the FDCPA. Something happened to my share screen here. Okay, so we have a section 1692E, and this is false or misleading representation. So this is subsection E. Well, it talks about you may not use any false, deceptive, misleading representation, collection of any debt, and you go down to 8. And if we just highlight all this, it says one example of false or misleading debt collection is communicating or threatening to communicate to any person credit information which is known or should be known to be false. So there's no prohibition against correct credit reporting, but if it's incorrect, then this would violate section E8. So from that standpoint, I would say that certainly reporting a debt is an attempt to collect a debt. There are some courts, I think they're wrong, but there are some courts who have taken what they think is a very technical approach. I think they're technically and actually wrong in it, but they say, well, merely credit reporting is not an attempt to collect a debt. Sometimes this can get a little confusing. What if you're in that validation period and they're still reporting? Is that collecting? And so that you really have to look at your particular part of the country, what it's called, what circuit you're in. So like I'm in the 11th circuit, which is Alabama, Georgia, Florida. The 5th circuit would be Texas, Louisiana, Mississippi, maybe Oklahoma, or maybe Arkansas. The 9th circuit would be the West Coast. 2nd circuit would be like New York. And so you really have to look and see how do your judges interpret that. But in general, I would say yes. Credit reporting is definitely collection of debt. And but just that little sort of asterisk mark that sometimes it gets a little squirrely there. Okay, so Carlos says now making payments, small payments, avoiding judgment, settlements offered very high. So yeah, if you've got Midland and you're making payments, I would just check my credit report. And okay, if I'm making $25 a month payments, is it coming down every month? $25, and if the credit report has a place under Midland for recent payment, does it show that? And I'll say this, Midland, and I've sued Midland probably more than any other company, I guess. So I'm not a big fan of Midland, but I'll say this, they generally do a good job of reporting the payments and showing that balance coming down. But it's definitely worth checking your credit reports on annualcreditreport.com. So JD Lewis says, what if you no longer live at the address they send mail to and you did not get the initial letter? Can they still put the debt on your credit report? So very good question. Once that Regulation F went into effect November 30th of 2021, last year, a little bit of controversy over, does it apply to past debt that's already on your credit report, but clearly new debt, okay, that goes on your credit report after November 30th. Either the creditor, the collector, and generally be the collector, they're supposed to write to you, okay? If they don't know they have the wrong address and they get no notification back that this is the wrong address, then they can rely on the fact that they sent this to the last known address and everything's good. Now, if they get, a returned envelope says no longer at this address, well, then they can't claim that that was good. So it's really a common sense thing, kind of like if you send an email notice as a debt collector and it bounces back, well, then that's no good. You can't go, well, hey, we notified them. No, it bounced back. Same thing with mail. It's just mail, obviously, it's a longer process before you would know that the letter was undelivered. Okay. Let's see. Miro says you have a donation button. Not that I know of. I've seen that on other things. I just haven't done that, but just appreciate you guys being on here, and I enjoy chatting with you. And so appreciate, your support. Let's see. We've got ECSI all of a sudden shows up a week ago as my student loan servicer erases 15 years of positive payments from my credit report. Bureau refuses to follow law. So a question I would have is that 15 years of positive payment history, was that from the prior servicer, and now ECSI is there and the old servicer is gone? So ECSI, or let's just take any servicer. I'm not familiar with that servicer, but just any servicer, they're not obligated, and really they should not report on the previous history because they don't know that. Okay, so if I have Bank of America as my mortgage servicer, and I'm, whatever, good or bad with them, and then Nation Star, or what's their goofy name, Mr. Cooper, they take over the servicing of my loan and they start credit reporting. They would just start with like that month. They would not say, well, we're going to put the 10 years of Bank of America. Now, Bank of America does not have to get off of my credit report just because they're no longer my servicer. But remember this, and I know this can be frustrating. No furnisher. So we have the credit bureaus. The furnishers are down here. They furnish information to the credit bureau. So it's your student loan, your car loan, your credit card company, your debt collector. No furnisher is required to furnish information. That every one of my creditors tomorrow could just, boom, we're not going to report anymore. I can't make them report. The only thing I can make them do is if they report, they have to report accurately and completely. But I have no obligation. I can put no obligation on them to actually report. Okay, they can just say, we're not going to report at all. So I'm assuming that's what happens. The prior servicer just deleted themselves off your report. And unfortunately, I don't know any way to make them do that because the law, in my experience from doing this for many, many, many years, is there's absolutely zero obligation to report. But if they report, then it must be complete and accurate. All right, Carlos says, please need a New Jersey lawyer referral, ASAP waiting on. Let me give you, let's see here if I can. I tell you what, Carlos, try the NACA thing. There's a couple of lawyers there. I'm not sure, where in New Jersey you are, but try that NACA. There's a lawyer in New York City and New Jersey. She'll kill me because I'm drawing a blank on her last name. Rachel's her first name. She's very good. You can find her on NACA or just reach out to me. And I've got all of her contact information. As soon as I stop this live stream, I'm going to remember her full name. And let's see. So we got Robert. Thanks for great information. Hey, appreciate you being here, Robert. And appreciate the interesting work that you're doing there with some of those complicated laws. So I've been watching you and pretty impressed with what you're doing. Let's see. Bloomberg. Yes. Okay. So Muriel, I heard from another YouTuber that if the debt is in the last year of statute of limitation, you can get it deleted earlier by calling the bureaus and asking it be deleted earlier, 6 months before it's scheduled. Well, I'll say this. I mean, no harm in doing that. You could call the bureaus. They're under no obligation to do that. But whether they have some policy to do that, I'd be very interested. So if you're in that situation, why don't you try that and then just report back to us and say, hey, it worked, it didn't work. Now, whether it works or doesn't work one time doesn't prove anything, but that would be interesting to know. Let's see here. So how do you collect a judgment from TransUnion? So if you have obtained a judgment against TransUnion, I'll be honest, I've never known them to not pay a judgment. But what you would do is you find where if in your state where you have the judgment, if they have assets there, then you would go about executing on the judgment. It's not my area of expertise because I'm on the other side, defending judgments. And like I said, I've sued TransUnion forever. I've never had a problem with them paying. If they have no assets in your state, you may have to what's called domesticate the judgment to where TransUnion is. Like I know they have a big office in, I think it's Philadelphia. So years ago, back in the Great Recession, so like 2007, 8 to 12, there was a lawyer in Florida who I think he got a judgment against Bank of America, and they are not easy to deal with, and they weren't interested in paying him. And so, I guess in Florida, the process is, most states it's this way. You get basically an order from the judge that allows you to go seize assets. Okay, called different things in different places, but anyway, he gets that order and he shows up at a Bank of America branch with a couple of sheriff's deputies, and they're like, we're here to start seizing computers and papers and desks and chairs. You can imagine, here's a good Southern expression for you. Bank of America had a come apart on that. Okay. I mean, can you imagine like all the data that would be on the hard drives of those computers? And so, suddenly they found a way to pay him his money. And so, anyway, I'm a little surprised TransUnion's giving you problems, but just talk to a lawyer probably a collection lawyer, who would know how you execute in your particular state. Then you said, is the only way to remove bankruptcy from a credit report show their inaccuracies? That's the way that I recommend doing it. There is another approach that I'm not a big fan of, just because I think it hurts your credibility if you have legitimate things that you're disputing. But if there's a bankruptcy and everything's reporting accurately, then, and I won't go through the whole process, but you get a letter from the bankruptcy court, says we don't verify stuff to the bureaus. You go to LexisNexis, you freeze your account, you opt out, you do all this stuff. And look, sometimes it works. Of course, it would also work if you just did an online dispute. There's nothing magical about that approach. But what I don't like about it is, and understand my perspective, I don't run a credit repair place. I don't charge people to do credit repair. What I do is I help consumers, mainly my own clients, but sometimes people who I don't represent, who say I want to become a client, is we help them dispute stuff. There's no charge for that, and we don't make any money unless the bad guys don't fix it, and then we sue. Well, when we sue, the credibility of my client is absolutely critical. And so I don't want there to be a dispute where there's a bankruptcy, it's got the right date, the right court, the right case number, the right open date, the right discharge date, and we're doing this thing with LexisNexis and a letter from the court, and I don't want that. So the other thing is, even if you get it deleted, the bankruptcy's still out there. If you apply for a mortgage, they're going to ask you if you ever filed for bankruptcy. If you lie, that can be mortgage fraud. So I just don't think that it's a particularly useful thing, but you can find people that will talk about this approach. All right, let's see. Credit bureau is liable for information is placed in our report. They're required to perform due diligence for allowing any information. That is true in a way. There's something called EB. So let me just share my screen real quick. So this is section 1681E under the Fair Credit Reporting Act. And we go down to B. It's a very short section, very powerful. And it says, let me get this out of the way here so we can see it. Whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy. And that's certainly what the law is. Courts have said there's a much higher requirement once you dispute something, because this EB would say to the bureaus, you have to, all these billions of pieces of information coming in, you would have to figure out that's accurate. And they do to some extent, but it's not a real high burden, even though ironically, it sure sounds like a high burden. But when you dispute something, you say, hey, this account and these 17 things with this account are wrong. Now they have a much stronger obligation. I'll tell you where this EB comes up a good bit. And this was something we talked about in our webinar today. And I'll put that on YouTube in a while, probably a couple of days. But it's on post-bankruptcy discharge. So after your bankruptcy discharge, what should your credit reporting show? And if a credit bureau knows that you have an account open here and then a discharge here, and then that same account shows a balance, well, that's not using, reasonable procedures to assure maximum possible accuracy. Now, we generally give them a certain amount of time. I usually wait 90 days before we pull the credit reports after a bankruptcy discharge. But so what you put is correct. It's a hard standard to sue under, and there's some other requirements about it has to actually be a technical credit report that a user has pulled, not just you getting your own, what technically is called a consumer file disclosure. So again, it gets into some details there, but okay, so let's see here. So Jay says we're going back to the dealing with debt collectors and requesting information. Just contract with their name on it, signed wet ink, or not anything with the consumer's name on. Yeah. So if there is a contract, then the collector should give that to you. If there's a written contract, sometimes there's not a written contract. You might go into the emergency room and you don't sign anything. Well, the law implies a contract there. So it really just depends on what you're dealing with. And I would just, explain what you need and why you need it. And I suspect they'll give it to you if it's a reasonable request. And to me, the contract is like a super easy, super reasonable request there. Let's see. I filed pro se a civil suit against a corporation committed the illegal actions which led to the multiple wrong amounts submitted to a credit bureau of court next month. So, Sharon, what I would say on that is if you're suing, well, let me back up. So you have your credit report. If you're suing because this company reported false information to the credit bureaus, unless you have a state law that allows it, you generally can't do that, or it's difficult. I won't get into all of it, but it's called federal preemption. If you're saying, no, I'm suing this company because they broke some state law, and then that had sort of a domino effect, which then led to the false information being put on my credit report, then you may be okay there. But I would certainly get with a lawyer. And even if you don't hire that lawyer to fully pursue the case, maybe they can just give you some advice and say, hey, here's your judge, here's the other side, here's the law, here's some arguments to make. I'll just say this, there will every now and then be somebody who does something pro se, in other words, without a lawyer. I'm not talking about like defending a small claims case, but suing the credit bureaus or suing, a big company, and they'll be successful. What you don't see is like the 500 other people that did that crashed and burned. And I'll have people come to me and they filed a pro se lawsuit and they settled it for $1,000. And they're like, was that a good deal? And I'm looking at it because maybe there's a similar case. And, if they sort of press me on, I'm like, I would settle that case for $100,000. They're like, really? I thought all I could get's $1,000. Well, I'll just say this, and some people may go, oh, well, that's, because you're a lawyer and you're egotistical. I don't think so. Okay. But if you are going to do this, by this, I mean, understand the Fair Credit Reporting Act, understand the FDCPA. This is not something you do in a 30-minute thing, or you watch a video for 30 minutes, or you listen to somebody on a weekend. I mean, this is something where you have to invest the time. Okay. It's sort of in life, we can dabble or we can be a master. Well, there's so many people that dabble and they know just a little bit, but they think that's the whole world. And really, they are just so inadequately prepared to go into court, and somebody does something a little bit unusual, or the judge says, yeah, but what about this? And they go, oh, well, I didn't know that. So if you're going to act as your own lawyer, put the work in, put the time in. I said this in the webinar at 1:00 today. My background is personal injury. So I've tried cases, I've taken depositions, done all that stuff. When I decided I wanted to get pretty serious about the Fair Credit Reporting Act, FDCPA, that sort of stuff, I printed off every case under the Fair Credit Reporting Act in the 11th Circuit. So that's Alabama, Georgia, Florida. I read every case. It was hundreds and hundreds of cases. Somebody says, well, I don't want to put that time in. Okay. But if you don't put that time in, you're not going to have the knowledge. Instead, you'll just have little pieces of knowledge, just little, describing the elephant if you're blind. You just like, well, this is what the tail feels like. Yeah, but you're not seeing the big picture. And so, and I say that, I mean, if you're doing a dispute, I'm not saying you have to spend hundreds of hours researching stuff, but particularly if you want to know the law or you want to do this on your own, first of all, I don't know why somebody would not have a lawyer suing under these consumer statutes, because the lawyer can get paid by the other side. Okay. But even if you have to give up, say there's no what's called fee shifting and you're giving up a percentage. I mean, I just see people who settle stuff on their own, and I'm like, yeah, any average lawyer would have got you like 10 times as much. And you were concerned about paying, some percentage of it. So if you're going to do it on your own, then say, all right, I'm not spending money, but I'm going to spend time. I mean, if I want to repair my own car because I don't want to pay the mechanic, that's fine. I'm not spending money, but I better be spending time learning how to do that. Okay, so we will wrap this up as quickly as possible. Appreciate all the questions here. Let's see, Eddington, if you put them back in money order, something like endorsements, agreement, debt will be considered paid in full, removed from my credit report. Let's see, is it true if you send it to a collection company, even if it was for less than the amount they wanted, do they have to remove it since they endorsed it and got paid? I'll say that that's sort of an old strategy. I mean, it's been around for many decades. And a lot of times the contract itself forbids this. Okay. In other words, you can't just send something like that to sort of a Dropbox. I don't mean the online thing, but these big companies will have places that just sort of get in, 10,000 checks a week or something. And those people are just like, processing them. They're not reading the correspondence on the check or on, attached to the check. And so a lot of laws now, and certainly a lot of contracts say this is meaningless. So you'd have to know about that. I'll tell you this, in 27 years of being a lawyer, I've never seen that work. Okay. I'm not saying it can't work. I just have never seen it work. All right. Let's see. Jay said, what happens if Bank of America reports a consumer's attorney in a consumer protection, litigation to the credit bureaus as a current address? This would be an FCRA. So yeah, we see this. I'll have my clients come in and I see 301 19th Street North, Birmingham, Alabama, 35203 as their home address. And obviously it's not their home address. That's my office address. And so where that typically comes from is you are, like you said, you're in litigation with a furnisher, somebody who furnishes information to the credit bureau. And what they do in their system so that they don't contact you, they put in your lawyer's address, okay, and your lawyer's phone number. So definitely with debt collectors, once they know you're represented, they cannot contact you. It's a lot of original creditors take the same position because some states require that, and they just want sort of a uniform thing across the nation. So then that sort of gets taken from that part of the system and uploaded to the credit bureaus, and the credit bureaus go, oh, you have a new address. So just by itself, it's not going to be a violation of the law. It could be, but what you really need to do is just dispute that and say, hey, that's my lawyer's address. Here's a copy of my lawyer's letterhead. My address is 123 Main Street. Here's my driver's license. Here's a utility bill. Fix it. And they normally will. Experience sometimes will be difficult. They'll say, oh, a furnisher provided this. And, my response is, so what? I didn't ask you who provided it. I told you to get rid of it. They go, well, you have to figure out which furnisher had it and talk to them. No, Section 1681I says any information that's inaccurate, having my lawyer's address as my home address, is inaccurate. And so, I would take some action against them if they did not fix it. And usually you can come up with other violations as well. Let's see, video stream is fantastic. Well, good. I'm glad that you've enjoyed it, and thanks for participating. And let's see, never got a letter from credit or company I work for. I'm not sure. Maybe I missed something. Sorry, over a 10 debt. So, Lady B, I may have missed something from you earlier. Maybe just give me a little context of what you're talking about, and I'll try to help you while we wrap up here. So, well, thank you. And I'm sorry the way this is set up. I don't know who you are, but thank you for saying that. And great to be seen. And yeah, Carlos, that'll be good. And let's see, for a repo, do they have to provide the pre and post sale documents if requested? So it's a good question. Let me give you sort of a couple of ways to look at this. Almost every state under the UCC, Uniform Commercial Code, says that a company like a car loan company must provide you a notice after the repossession, but before the sale, that says, hey, we have your car. We're going to sell it at a public auction, a private auction, blah, blah, blah. And then after they sell it, particularly if there's a deficiency, so you owed $15,000, it brought $10,000 at the repo sale, so we owe $5,000 that we're deficient in, that send you a letter after that sale explaining that you owe $5,000. So you certainly can request that. Let me say it this way, the effects of a company not sending, particularly that post, in other words, after the sale deficiency letter, that varies by state. there are some states that say absolute bar. You cannot sue the consumer for any deficiency because you did not send that letter after the repo. Some states say it's wrong, but the consumer has to prove how they were harmed by not getting that letter. And then other states have kind of an in-between. So you really have to figure out what state you're in. But yeah, you can request that information from them. And then, what you may find is that you moved and you told the company you moved. And 9 months later, or 15 months later, when they sold the vehicle, they sent it to your old address that they knew was not the correct address. That would be very useful to know. Okay. Let's see. Sharon says, answers really appreciated. Thank you for giving time. Well, you're very welcome. And I enjoyed doing this. And Muriel, thanks for sharing your knowledge. Wish I could donate. Well, you just, go help somebody else. And that will be wonderful. And, if we all help each other, not to try to sound corny or something, but if we all help each other, it makes the world a better place, particularly in this crazy time with what's going on. Let's see. There's my friend Timothy Williams. Good stuff. Hey, good to see you, Timothy. Well, listen, guys, I've got to run here. Thanks for sticking around, and we'll catch you again in a couple of weeks. And hope you have a fantastic rest of your week and a really good weekend. Okay, have a good one. Bye-bye.